Hello viewers, welcome to Access to Justice module, and our discussion is going to be on informal access to justice. The name itself is quite interesting, because when we talk about informal thing, that means it does not have any regular authorities to regulate it, or it may be that there is no exact procedure to be followed, or maybe it is a process where the enforceability would be a issue. So, keeping these things in the background, I am going to take up a discussion on informal access to justice. When we talk about informal access to justice, means there is an access to justice which is formalized, which is a formal one, that is courts, a judicial setup. When we talk about informal access to justice, we are talking about something else other than the court process. The question is, why we are talking about informal access to justice? Is it because our formal justice is defective, or is it because the defects of formal justice are such that that cannot be rectified, or is it that certain kind of dispute shall or should pass through this informal process? My request is that do not encourage this informal process because you find fault with formal system, but you encourage this informal system because you find it advantageous for certain kinds of disputes. Informal access to justice is popularly known as ADRS, Alternative Dispute Resolution Systems, and there are two modules which deal with this informal justice system. Today's module is going to be on negotiation and mediation. Myself, Dr. B.S. Patil, Assistant Professor working at V.M. Sargonkar College of Law, Goa, and my discussion would be on negotiation and mediation as informal access to justice. To start with, let me impress upon the equal justice to all. Is it a reality, or is it just a fake promise made? Equal justice for all. When you go to court, do you think that both parties are put at equal footing, so that the parties are heard with equal detachment, and then finally there is a decision on the court where the court treats both parties equally? My answer is no, because when you talk about equal justice for all, we are talking about presentation of case by a lawyer or an advocate who are equally competent. Take an example of a person with very well off and with a lot of resources available. You would employ the best lawyer in the town, and best lawyer in the town provides best service possible in the town. With best service possible in the town, he is going to provide or present the case in a best possible way and tilt the law in his favor with his pure acumen on law. Therefore, equal justice for all may not be true all the time. This is only one part of the problems that we are facing. The other part of the problem is courts are having series of problems like unpredictability, same set of facts, same cause of action, same parties, we get different verdicts. Trial court says plaintiff is entitled, appellate court, first appellate court says defendant is not liable, second appellate court says plaintiff is again entitled, but not the same amount, different amount, different orders. Why there are different verdicts on same set of facts? It is because of unpredictability of the court proceedings. Expensive, surely court proceedings are really expensive, because not only that the court fees, advocates fees are exorbitant, in addition to that the cost of litigation multiplies as you are made to visit the district headquarters frequently, and the transportation cost, the time hours of work that have been lost, the labor that has been lost, if you add up all of them, it would be a very expensive process. Political interference, I do not think it is a major problem, because judiciary has insulated itself from exterior influence, but definitely it is one of the issue to be looked into. Interestingly, the major problem is technicality. When you talk about technicality, the code supposed to follow the procedure, and if there is a fault in following of the procedure, the decision would be set aside. To follow the procedure, too technical, too much of delay, and the technicality definitely going to lead to another issues relating to expertise. Judge is technically competent in procedural law, that is CPC, but is he technically competent to deal with the specialized nature of the dispute? Take an example of a dispute relating to designs, dispute relating to copyright, simple dispute relating to construction. He has to understand the terminologies used in that construction business. He has to understand the kind of materials that are used, the kind of language they used when they measure the construction area, constructed area. He has to understand the technical meaning of each word spoken, and mostly they speak in abbreviations like most of the lawyers do. So, how to handle these, the lack of expertise? What happens is, when a judge is not expert in that area, he spends more time in understanding the nature of business, causing delay. What I have done now is I have picked up unpredictability, uncertainty, political interference, but what I have left out is one vicious cycle. The cycle, the final result is delay. Why there is a delay? Because there is backlog, because there is too much of technicality, because there is too much of uncertainty, because of lack of expertise. See, delay and backlog are interchangeable. The more the delay, the more the backlog. The more the backlog, there would be more delay. So, delay and technicality are again correlated. Too much of technicality, too much of delay, and too much of delay, too much of backlog. So, therefore, all are interconnected, and to address these problems, we need not address each one separately. Once one problem is addressed, whereas they are interconnected, all could be solved simultaneously. But I am not standing here to provide solution to these problems. I am here to talk about an entirely different proceedings other than these court proceedings, that is informal justice system. So, anciently we had two systems. I am not big fan of both the systems, because they were not appreciated because of influences they were undertaking, the social influences that they were exerted on these systems. One was situation specific system. A matter comes up before the leaders of the village decide based on the situation and based on the requirements. But there is another system which is more suitable, that is interest based justice system, where the dispute, when brought before the village heads, the village leaders, they look into the interest of both the parties and decide in such a way that the interest of both the parties are protected. So, when the interest of both the parties are protected, we are ensuring the adherence to the decision. They accept it and they love the outcome of the proceedings. So, this interest based system is being developed further into informal system. So, when we talk about informal system, we are talking about four systems, that is also known as 4 methods of ADRS, alternative dispute resolution systems. Negotiation is one such thing, which is the primary process, and here the two persons sit across the table, discuss, talk and solve the dispute. I do not think it would be as easy as I mentioned, but this is how the procedure goes on, and with lot of hiccups in between, deadlocks in between. Mediation, again same thing, there is two parties sitting across the table, discussing the matter, but interestingly in presence of a third party called a mediator. And what this third man is doing when two parties are discussing their problems, this third person is intervening at necessary point of time, ensuring meaningful discussion among the parties. Conciliation is the third ADRS, which is similar to mediation, where two parties are talking, discussing their problem in presence of the third person, who is again playing similar role like mediator, intervening with the parties, encouraging the parties to go for discussion, facilitating the parties to come up with a proper outcome. Arbitration, it is the most advanced ADRS, where the parties are presenting their case. There is again parties sitting across the table, but they are not talking to each other, they are not discussing between each other, but they are presenting the case to this third person, who is a private judge, and this private judge would pronounce a binding order, a judgment which is called as the award against both the parties, and the parties have to obey the orders of the arbitrator. So, the difference between arbitration and other ADRS is that the parties do not have the freedom to walk out of the proceedings, parties do not have the freedom to refuse the instructions of the arbitrator, but whereas parties can refuse to listen to mediator and conciliator, because they hold the complete control over the process. So, with this brief background of the ADRS, let me take up under today's discussion the two aspects of ADRS or informal justice system, that is negotiation and mediation. And in my discussion I am going to talk about negotiation, process of negotiation, and the requirements, qualities of a good negotiator, and brief discussion on law relating to negotiation, and similar procedure I will follow for mediation. When we talk about definition of negotiation, here the parties are into discussion mode, they try to compromise and achieve an amicable settlement amongst themselves through the process of discussion. Please read the sentence which is there in the marked in red. Negotiation is achieving what parties want by convincing the person to whom parties want, from whom the parties want. So, here when I talk about compromise, the thing that comes to your mind is compromise means you give. Why can't you take it this way? Compromise means you take. So, negotiation is not about giving, negotiation is about taking. Negotiation is about taking what you want, giving what they want. So, it is how the whole negotiation should be planned and should be implemented. So, it is not a place for competition, it is a place for cooperation. So, when we talk about negotiation, it requires three basic skills. The basic skills are the communicative skill, where the party needs to communicate effectively. Now, to communicate effectively, they need to articulate the same. First, they have to understand their requirements, put the requirements in a manner which is appealable to other person, and communicate that. So, communicative skill is one of the basic important requirement. Second one is interactive skill. Presenting your case is not the end of discussion. When we say discussion, you should also have good ear to listen. So, listening skill, responding to the problems of the other person, showing empathy to the other person, these all form interactive skill. So, you have to listen verbally and non-verbally, you have to show empathy to other person's problem, and that is another important skill for a negotiator. Third one is convincing skill. So, once you articulate your requirements, once you show empathy and other thing, then you put forth your requirements forcefully, ensure that the other person agree to your requirement. That is convincing skill. So, once you possess these skills, you could be a good, efficient, effective negotiator. What are the advantages of this negotiation? And when I speak about advantages of negotiation, I am speaking advantages of mediation as well as conciliation. So, when advantages faster, negotiation is under the complete control of the parties. Decision can be taken faster, whether to go ahead with negotiation or to end the negotiation process and look for other options to resolve the dispute. The decision can be taken quickly. If you decide to continue with negotiation, settlement could be arrived very quickly because it is under complete control of parties. Less expensive because you can fix the time and place of your convenience along with the convenience of the other party. As the convenience of the parties is taken into consideration, you can keep the expenditure to the bare minimum. And also it is important to note that when negotiation can be resolved at a faster pace, it can also ensure that the expenses are kept at bare minimum. Client's involvement is another biggest advantage of negotiation process. In all other process, court, arbitration, the client is kept at the periphery, and in the center it is the advocate who is giving the performance, and based on the advocate's performance the decision is given, and client has absolutely no control over the proceedings. But for a change, in negotiation and mediation, it is the client who is sitting at the center of the happenings. At the periphery, it is the advocate who is sitting there and looking into the matter. So, therefore, client's involvement is maximum in negotiation and mediation. Integrative approach. This is a process which brings parties together rather than divide them. In court proceedings, the court being an adversarial approach, court showing an adversarial approach, make sure that the relation between the parties is damaged, but whereas negotiation ensures that the relationship is built up between the parties. As I have already mentioned, negotiation cooperative rather than competitive, give what the other party wants, take what you want, let both parties be happy. As this is the approach of the parties, develops less ill will among the parties, the relationship is protected and both parties would be happy with the outcome of the proceedings. So, from advantages, let me move on to the kinds of negotiation. Generally, there are two kinds of negotiation which are adopted knowingly or unknowingly. One is hard negotiation, the other one is the soft negotiation. Hard negotiation, the party enters the negotiation chamber with an attitude to snatch everything possible from the other party, destroy the other party's needs and requirements, harm the other party's interest, so that he can achieve maximum what he wants. In simple word, hard negotiator comes with an attitude to exploit the other party. So, when you come with that attitude, you tend to behave aggressively with the other party, and this aggression can lead to fight between the parties. On the other hand, soft negotiator is quite opposite to hard negotiator. This man enters the negotiation chamber with one important objective: protect the relation between the parties. So, his concentration is on protecting the relationship rather than gaining advantage through gaining advantage in the dispute. So, therefore, he enters, treats the other party as a friend and tries to make offers so that the other party agrees to the resolution of dispute and he can protect the relationship. So, these are the two kinds of negotiation. Now, let me talk about the consequences. Now, let us see, a soft negotiator meets another soft negotiator. What happens? Both are making offers, both are soft, both are interested in protecting relationship. 100% there is going to be a settlement of dispute, and 100% both parties are going to be happy, best result. Take another situation where both parties are hard negotiators. So, when both are hard negotiators, both come to exploit each other. So, there is a hard negotiation where the parties treat each other as enemies, fight ensues, and at the end, breakdown of negotiation, they walk back, next day they meet in the court. But the problem is the third situation, when hard negotiator meets a soft negotiator. It is a classic case of exploiting the soft negotiator. He would be exploited thoroughly. He thinks that he has successfully protected the relationship. Hard negotiator thinks that he has exploited sufficiently, and there ends the matter. So, my question now is, which one you want to be, hard negotiator or soft negotiator? Which is preferable? Which is the better option? My answer is none of them are a better option. It should be the principled negotiation rather than hard or soft. When I say principled negotiation, I am not talking about morals and ethics. I am talking about the 7 principles which are created by Harvard Law School. Professor Urey and Professor Fisher of Harvard Law School, they have come up with 7 principles to be followed during negotiation process. Once you adopt these 7 principles, you can successfully deal with any kind of situation. You do not treat the other party as a friend or enemy, you treat other party as other party who is in need of resolution of dispute, and you will resolve dispute if all 7 principles are fulfilled. Let me go through those principles one by one quickly. Interest. So, when we sit for negotiation, we should assess the interest of the other party and interest of our own. So, when we check the interest of other party and our own, we can list out 2 kinds of interests, conflicting and common interest. See, conflicting interest is the reason why we are here on a negotiation table, because the conflicting interest has led to the dispute. So, those are listed. Why you need to list the common interest? Because these common interests are going to help us in convincing the other party that the negotiation is the best way, because we have so many things in common, and that would be a convincing answer to the other party when he is trying to walk out of negotiation process. So, that is why interest should be assessed. Options. To be a good negotiator, you should learn to think out of the box. So, options here I mean different ways in which you can settle the dispute. So, you offer them an agreement A, these are the things you are offering them. So, if the agreement A is rejected, then you go for agreement B, agreement C, you generate as many options as possible. So, when you generate options, you are asking the other parties to agree to it. So, that is the best way to resolve dispute. Rather than talking in one term, you should talk about in multiple terms. Something would appeal to their requirements. Third one is alternatives. So, when I sit on negotiation table, I do not sit at the table as the last option available in the world. I always explore alternatives. If negotiation fails, what I am going to do next? Once I have strong alternatives at my disposal, I would be a very confident negotiator. I will not be bullied because I have strong alternatives. So, that is another thing which needs to be checked. Legitimacy. When I make any demand on a negotiation table, I should legitimize my demand. If I say I should be compensated with 1 lakh, immediately I should ask question to myself, why not 99,000? Why not 1,01,000. Why it should be 1 lakh only? So, I am going to give justification, and justification provides legitimacy to your demand. Once you make a legitimate demand, refusing becomes very difficult. Relationship, and this is one reason why we are on a negotiation table, because the relationship needs to be protected, and the relationship can be protected only when you have a proper communication. Now, communication, to and fro talking, avoid misunderstandings, select the one method of communication and only one person should communicate. It is to avoid all the confusions and misunderstandings. And last one is the most important, the commitment. When we settle a dispute, we enter into an agreement. If the agreement is not respected, what happens? We go to court to enforce that agreement. So, we go to the court and tell the court that we had negotiation, we had settlement, and settlement led to this agreement, and the other person is not respecting it. So, please enforce it. So, whatever we have achieved through informal justice system came to naught, because we are finally we are before the court. So, why the other party has gone to the court? It is because the other party feels that the settlement agreement is not in his favor, it is not for his benefit. So, therefore, obtaining commitment to the settled agreement is very important, otherwise you would end up in the court again. So, these are the principles should be followed in the court proceedings, in the negotiation proceedings. So, therefore, hard, soft are not the method of negotiation, it should be principled negotiation. So, with this background, let me move on to the discussion on law on negotiation. There are two provisions which I have taken up for discussion. The provision one is that is section 80 of CPC. When a person has supposed to file a matter, a case in the court against the state, either the state government or the central government or a public officer, he is supposed to give 2 months notice. The question is, when I file a case against any other private party, I need not give notice. Why notice should be given to state only? So, this question was answered by the court in Bihari Chaudhary versus State of Bihar. The court said this 2 months notice, there is an interesting reason behind it. The reason is those 2 months will be utilized by the state to resolve the dispute. They first investigate the wrong done, if they will try to contact the party, they will try to negotiate with the parties. If they find that they are at fault, they try to resolve the dispute amicably without going to court. That is the purpose of this 2 months notice. Again, this 2 months notice has exceptions also, that if the matter is of urgent emergency, then the court can waive off this 2 months notice requirement and they can take up the matter directly without giving notice. This is the objectives of the law, but actually what happens? Sadly, the 2 months is never utilized for negotiating and settling the dispute. 2 months are instead utilized for preparing brief that could be presented before the court. So, even Law Commission of India felt that the object of the section 80 has not been fulfilled, has not been understood by the state, and it has been just dead letters in the statute book. So, this is about section 80. The other one is compromise decree. So, when the matter is filed before a court and when the court is going through the matter, whatever may be the stage of issuing a summons, stage of trial, whatever may be the stage, the parties are free to negotiate outside the court hall. So, when they negotiate outside the courtroom and they try to settle the dispute, it is very much within their powers. So, what happens here is court encourages outside the court settlement. Whatever is settled outside the court can be converted into decree of the court. So, what happens here is we are agreeing for something for which you are getting the seal and signature of the court. It is as good as a decree, as good as enforceable right under the law. So, what happens here under the compromise decree process, there are two important things which attracted my attention was suit adjusted wholly or partly could be presented to the judge. So, we can present half cooked negotiation agreement to the court and the court would say that 50% of the case is resolved through negotiation, remaining 50 I am going to decide based upon the evidences. So, when suit is adjusted partly, the remaining part would be taken up by the court. The other issue is another interesting one is proved to the satisfaction of the court. So, once a settlement agreement is brought before the court, converting that settlement into decree of the court is not a mandatory process. You can't force the judge to sign it, and also second thing is it is not a mechanical process also. Now, judge has to take two precautions. Number one, whether the negotiation process involved any kind of mistake, misrepresentation, fraud, coercion, those chances should be ruled out. So, that means he should ensure that consent is a free consent. Second, he also should check the terms and conditions in the settlement agreement, whether they are within the ambit of the law, within the limits of the law. So, only once he is satisfied with these things, he is going to convert it into a compromise decree. Then there is notice, the issue of notice. Whenever notice is issued, the object is that can't you settle their matter rather than going to the court, but mostly the notices are responded with a counter notice, matter ends up in the court. But this is an attempt by the law to encourage negotiation. Let me move on to mediation from negotiation. Now, here again definition of mediation, I call it as an improvement over negotiation process. I term it as an evolved and improved version of negotiation. Why it is an improved and evolved version of negotiation is because that there is a third independent impartial person who is manning the whole process, and the presence of this third independent impartial person is going to ensure that the negotiation runs on track without any delay. So, it is the third party who should possess two important qualifications. Number one, as I mentioned, independent and impartial. So, he should not be connected with neither of the parties, and in his behavior he should not show that he is going to favor any of the parties. In addition to this, he should also enjoy another qualification, that is trust and faith of the parties. Parties must have faith and trust in him, then only the mediation can go effectively. So, his role is avoiding deadlocks, so that the discussion is meaningful, and then facilitating the parties to come to a settlement of the dispute. So, how does he achieve these things, avoiding of deadlock and facilitating the parties to come to an amicable settlement? He would do that by following a procedure which is similar to those principles which I had made mention while discussing negotiation. First, he would identify issues involved in the dispute, that is identifying interests. He would try to reduce misunderstandings, means he is going to develop a proper communication between the parties. Clarify priorities, means he is identifying the interest of the parties, he is identifying the expectation from the negotiation process. He would explore the areas of compromise. So, what he is doing here is he is generating options, assisting the parties in generating options. He not only generate options by himself, he would assist the parties to come up with the options. Mediation has been predominantly a non-statutory authority. No law proposed mediator, he always worked outside the scope of law, but always he was successful in resolving the dispute. Whatever he achieved would be converted into an agreement. Agreement means a contract, and its contract could be easily enforced. But things changed from the year 2002. By insertion of section 89 of CPC, the mediation became almost a statutory authority, because now he is coming within the ambit of law. and in a court annexed mediation he is going to function under the laws of mediation. So, under section 89 of CPC, it is important to note that it was the recommendation of Law Commission, that is 129th report of Law Commission recommended that we should go for ADRS and encourage people to resolve the dispute. The recommendation got the support from an experience of Himachal Pradesh. Conciliation courts were set up in Himachal Pradesh to resolve rent disputes, and the success of that experiment at Himachal Pradesh encouraged the legislatures to come up with this amendment. Later on, as usual, the matter was passed in the year 2002, it became a law. Later some issues was raised, most importantly the constitutionality of section 89. When this was questioned, court disagreed, they said it is very much constitutional. Then there was another case, that is Afghans case. This Afghans case 2010 is, they found there is a lot of defect with the drafting of the law. So, they say that if the law, that is section 89, is implemented literally as written, it will be a trial judge's nightmare. It puts a cart before the horse and lays down an impractical, if not impossible, procedure. So, they are finding that there is a basic flaw with the drafting of the section, that is what Supreme Court felt in Afghans case. So, let me understand and let me explain the procedure under section 89, then you can go ahead with your own opinion whether it is the cart before the horse or what you can make out. So, what happens here is, first the judge is going to make the list of admissions and denials in plaint and written statement. Each admission is fact admitted and fact settled. Denials, fact needs to be heard, those becomes issues, and then he is going to check the chances of settlement. Now, here how he is going to check the chance of settlement without hearing the parties, that is the issue. Formulate terms of settlement. How he is going to formulate terms of settlement based on only those two documents, that is another issue. So, once the terms of settlements are formulated by the judge, it should be communicated to the parties, and parties would submit their recommendations and observations within 30 days, and there would be reformulation of the settlement agreement. And this procedure seems to be a little too early to resolve a dispute. It should have been postponed at the later stage. That is the opinion of the court under Afghans case. So, when let us move on to mediation under section 89. So, mediation is based upon the rules established by the court under Civil Procedure Alternative Resolution Rules 2006. These rules prescribe the procedure to be followed by the mediator. Now, first let me talk about the role of the court in mediation process. So, if the parties unanimously decide that they want to go for mediation, the court is bound to refer them for mediation. They will make an application to the court, and based on the application they would be referred to them. But if there is no unanimity, if there is non-response from the other party, then there would be an application to the court stating that the other party is not responding. What to do? So, then the court would issue a notice stating that the other party is thinking of mediation, what is your answer to this? In that, if the response is positive, matter will go to mediator, but if the response is not given, then court would make a decision, because now the ball would fall into the court. Then if there is no unanimity, then again the court takes up the decision making power, and they would send the parties to the mediator or judicial settlement, whatever the court feels fit. Then there is a specific bar that court cannot send every and any dispute to mediator or ADRS, like a case where next friend is representing instead of the party himself, maybe because the party is minor, or maybe the party is disabled, or is insane. So, these people cannot go for mediation negotiation, and in representative suit again they cannot go for mediation and negotiation, because it is not supposed to be settled by the court. So, even though these are exceptions, court can overrule these exceptions by exercising veto, because if the court feels that they can protect the interest of the minor in the whole process, they can ask the guardian to negotiate and settle the dispute. So, now again continuing with the role of the court, the power to refer is exercised with the consent of the parties, but the power to refer also comes with power to review. So, they can review the reference of a dispute, or they can review the non reference of the dispute. They also enjoy the power to withdraw the reference. They also enjoy the power to prepare the panel of mediators, so to whom the parties can refer the dispute. Then very importantly, they also enjoy the power to remove and delete. When I say remove, I am talking about a mediator who has certain interest in the outcome of the case, he would be removed and replaced. Delete is when a mediator is found to be inefficient, ineffective, he would be removed or deleted from the panel of our mediators. So, that is deleting. So, removing is from one mediation process, but putting him in another mediation process, but deleting is removing him from the mediation activities altogether. So, then the appointment of the mediator is done again by the parties if there is unanimity. In case of lack of unanimity, court steps in and they adopt direct and indirect process. In indirect process, the parties will appoint one mediator each, and the mediators would appoint the sole mediator, that would be the mediator who is going to handle the matter. So, indirectly parties are making an appointment because of lack of unanimity. Then freedom of selection, parties can select mediator from the list available, or they can go beyond the list and select anybody they want. So, they have a complete freedom in selecting the mediator. Qualifications of mediator, interestingly, if you look at the list, they talk about retired judges of Supreme Court, High Court, District Court, Civil Court. They talk about lawyer with 15 years of experience. They talk about retired senior bureaucrats. So, if you take the look at this list, I find that the role of the mediator is not to decide, role of the mediator is to facilitate, role of the mediator is to encourage. But these people, the list that is given, I find that they are not very suited to mediation, they are very suitable for arbitration. But other than this, there are experts of our other professionals, there are expert institutions who can act as mediators. I find they are more suitable to it. So, the reason why I am saying that they are not suitable is because the way they have led their life as a deciding authority, now they cannot decide, they only facilitate. That would be a little difficult to adopt. Disqualification, who cannot be mediator are the people who are insolvent, unsound mind, who are having criminal charges of crimes involving moral turpitude, disciplinary proceedings pending, are charged or even convicted. Interested people cannot be mediators. Legal practitioner who has represented any of the parties or representing any of the parties cannot be mediator, or any other disqualifications as notified by the High Court. So, these are the qualifications, disqualifications. Now, coming to the role of the mediator. So, first role is expressing his independence and impartiality by communicating to the parties that he is completely independent and impartial. If there are any circumstances which gives rise to doubts as to his independence and impartiality, must be communicated in writing immediately, and this duty to communicate operates beginning till the end of the mediation process. Then he is supposed to facilitate voluntary resolution of dispute, and he is supposed to develop efficient communicating process between the parties. As I already mentioned, the role of the mediator includes identifying of issues, reducing the misunderstanding, clarifying priorities, exploring the options to resolve the dispute, and he should keep on emphasizing that it is the parties who is supposed to decide and resolve the dispute rather than mediator suggesting it. There are ethical issues which the mediator should address, that is, he cannot behave unbecoming of mediator, integrity and fairness should be shown, fair communication, adequate understanding of the procedure should be shown as well as communicated, qualification and professional approach should be adopted, adhered to, and justifiable doubts and of independence and impartiality should be communicated without delay. The appearance communication should not be improper, trust and confidentiality should be shown and he should remain faithful to it, conduct the proceedings according to law, and the principles of self determination should be upheld by the mediator and should avoid suggesting or deciding for the parties, and reasonable expectations should be communicated, and you should refrain from making promises that he is going to resolve the dispute, he is going to get maximum for the parties. Such promises should not be made. So, procedure of mediation, as I said, time, place, date, everything would be fixed by the parties, but if parties fail to come to a conclusion on that, parties would decide for the mediators. So, once the mediation is completed, then comes the issue of settlement of the dispute. So, when we talk about settlement of the dispute, there are two issues in this. One, during negotiation process, mediator is supposed to contact the court or not. The answer is no. He is not supposed to contact the court because it is a confidential process and he is supposed to keep it very secret. So, therefore, communication should be limited to failure of the party to appear, why he did not appear, that can be communicated to the court. If the mediator finds that the dispute cannot be settled because of it is unsuitable for settlement, that could be communicated. Settlement arrived at, communicate the settlement agreement to the court, or any other thing you want to communicate, the mediator is supposed to take the consent of the parties and communicate. So, when you go for mediation, two things are possible: successful, unsuccessful. When it is successful, you draft it into writing, the agreement, attest it with the party's signature, attest it with the advocate's signature, write a covering letter, and the covering letter with the signature of the mediator, it is sent to the court. But if mediation fails, then the report should be submitted that the mediation has failed, but the report should not contain as to why it failed, how the parties behaved, and what was the reason for the failure. Nothing should be communicated to the judge to prejudice the judge against any of the parties. So, these are the two things that needs to be communicated. So, this is a brief discussion on mediation and negotiation as an informal process of justice. I am going to discuss the other two, one that is conciliation and arbitration in the next chapter. Thank you very much.